Dr. Rainer Füllmich was sentenced to 3 years and 9 months in prison, with 5 months of pretrial detention not being credited. Thus, the severe prison sentence announced by the court at the beginning of the trial has been confirmed. The announcement came at an unexpectedly late hour, as Dr. Füllmich had just delivered his final statement, and several more trial days had been scheduled. The charge of embezzlement in 2 cases was clear to the court from the outset. The assets of the non-profit entrepreneurial company Stiftung Corona-Ausschuss Vorschaltgeogengründung were misappropriated through his actions. The defendant's argument, a private loan means that I can also use the loan privately. Ende Gelände. The court did not follow. But neither the willingness to repay nor a possible agreement from the co-shareholder Vivian Fischer was decisive. Because, even if one had assumed this, in favor of the defendant, the chairman stated, the Articles of Association stipulate that the shareholders should not receive any benefits. That the Corona investigator wanted to protect the company's assets from state seizure by offering his property as repayment security, the court did not accept this, as one could have defended against unlawful seizures by the state using the state's own legal means. In his final statement, the system critic, who has returned his legal license, gave a legal lecture on the offense of breach of trust and the danger of its misuse. The liquidity crisis is pure show. A sham contract agreement was invented to get rid of the loan agreements. Civil law was also pushed aside, with the aim of prosecuting a critic of the coronavirus measures, said the defendant. To counter the accusation of the very flexible offense of breach of trust under Section 266 of the German Penal Code, all relevant circumstances, and the behavior of all parties involved, should have been considered in the overall assessment, according to Dr. Rainer Füllmich. The investigative work as a decisive performance criterion was ensured at all times, as he, together with Vivian Fischer, continuously conducted investigations, even internationally. The purpose-specific allocation of donations from donors or benefactors was therefore always guaranteed according to him. Dr. Füllmich admitted as his mistake that he trusted the wrong people when he wanted to establish a foundation with the former co-partners of today's complainants, which never reached registration in the commercial register due to the lack of recognition of its charitable status by the tax office, which was a prerequisite for the formation of the corporation. From the defense's perspective, no damage could have occurred. The court sees it differently. In this case, not only do diametrically opposed legal opinions meet regarding the civil law issues surrounding donations or gifts, rather, the court and the defendant fought each other to the utmost. Thus, the defendant accused the court of kidnapping, the denial of legal hearing before the conclusion of investigations, lack of investigations that could have contributed to his exoneration, white torture in custody, incomplete files, shortening of the taking of evidence, ordering of written proceedings, restriction of the defense's questioning of witnesses, and thus, judicial perversion. The court, on the other hand, accused the defendant and the defense of abuse of law. Instead of convincing the chamber of their legal opinion, a coordinated process behavior with the defendant was used to provide both him and the defense a platform to influence the public and spread the defendant's political messages to the Füllmich supporters. Additionally, adventurous stories were spread by Dr. Misery, for example, that the chamber had a mandate to convict and that the intelligence service was behind the proceedings. The very last word was had by the majority of the spectators and trial observers present, who expressed their displeasure with the verdict after it was announced, by stating that it was not delivered in our name. No, that's not true. The mainstream press, which was absent for the verdict and also during almost all trial days, was addressed. The mainstream press resorted to sensational headlines to report on the so-called lateral thinker lawyer and his conviction. Here are some headlines. Corona denier. Corona informer in quotation marks, mind you, lateral thinker lawyer. Deciding whether this is a politically motivated case or not, I leave to your own judgment.
They want to keep me here for a few more years.
They won't manage that, Rainer.